Picture a towering skyscraper, half finished, just piercing the skyline. You look at it, and the sheer physicality of it is overwhelming.
Oh, absolutely.
You see the thousands of tons of reinforced concrete, the lattice of steel beams, the cranes pivoting overhead. It's tangible. And if you ask anyone on the street what is actually holding that structure up, they will point to the steel and say, that.
Right, the steel.
Yeah, and it's a comforting thought, right? Because we like things to be visible, calculable, and safely categorized into load-bearing and non-load-bearing.
It is entirely comforting, but it is also a complete illusion. I mean, the physical steel isn't actually what is holding that mega project together.
Exactly. Step into the world of commercial management and construction law, and you quickly realize that the true foundation of any of these projects is entirely invisible.
Totally invisible.
We are talking about a highly complex, incredibly fragile web of legal obligations, risk allocations, and commercial agreements. If that invisible legal web snaps, if a single poorly drafted clause triggers a cascade of insolvency, that physical steel means absolutely nothing.
Nothing at all. The cranes stop.
Right? The gates get padlocked,
Yeah.
and the project just collapses into a black hole of bankruptcy and litigation.
Which is precisely the reality that separates, the novices from the true professionals in the built environment. Navigating those murky commercial waters requires a very specific type of vision.
Yeah.
You have to be able to look at a standard concrete pour and see the cash flow implications. You need to see the liability limits and the risk transfer mechanisms operating beneath the surface.
And giving you that exact vision is our mission for this deep dive. If you are tuning in right now, you might just be catching up on industry standards, or maybe you're fascinated by how billion-dollar infrastructure is actually executed behind closed doors. Or, and this is a big one, you might be preparing for one of the most grueling milestones in this industry, the APC.
Ah, the assessment of professional competence. It is the ultimate crucible.
Yeah, it really is.
Whether you are aiming for your chartership with the RICS, the Royal Institution of Chartered Surveyors, or the AIQS or the IQSSL, this is the final hurdle.
And for those not in the trenches, the APC isn't some written test you can just cram for. It is a panel of veteran professionals grilling you face-to-face on your commercial acumen.
They don't want textbook definitions.
Exactly. They want to know how you react when the project is on fire, the client is screaming, and the contractor is threatening to walk off site.
They are testing your practical reasoning. They really want to see if your hands are safe enough to hold the financial fate of a multi-million-dollar asset.
So we're going to simulate that exact environment for you today. We're taking you through a premium, long-form coaching masterclass. We're going to place you right in the hot seat.
Put you on the spot.
Right. We will tear apart the entire lifespan of a construction project from a strictly commercial perspective. We'll start at the bedrock of contract formation, navigate the strategic minefield of procurement, wade through the daily warfare of post-contract administration, and finally end up in the most adversarial arena of all.
Claims, disputes, and professional ethics.
It's a massive journey. But if you can master the interconnected logic of these phases, you won't just survive an APC interview. You will possess a conceptual framework that applies to almost any commercial crisis you ever face in your career.
Absolutely.
Okay, let's unpack this. We have to start at the absolute foundation, and that is contract law. It is honestly shocking how many professionals in the industry operate every single day without truly understanding what a contract actually is.
Oh, it's terrifying.
They think it's just, a PDF sitting in a shared drive with some signatures at the bottom.
Right. That is the physical manifestation of the contract, sure. But legally, a contract is a meeting of the minds.
A meeting of the minds.
Yeah. The document is just the evidentiary record of that meeting. And if you are sitting in your interview and the panel asks you to define a valid contract, just rattling off a list of elements like a robot is going to put them right to sleep.
Yeah, you'll fail right there.
You need to explain the mechanics of why those elements actually exist.
Okay, let's test that theory with a scenario. Imagine a major developer taking a civil contractor out to a really expensive dinner.
Okay, I'm picturing it.
Over steaks and, say, a few bottles of wine, the developer enthusiastically, verbally promises the contractor a massive infrastructure package. Let's call it a new privately funded toll road.
Huge project.
Right. They shake hands. The contractor, eager to get ahead, wakes up the next morning and immediately mobilizes. They sign heavy equipment leases, they hire a specialized workforce, and they take out a massive bridge loan to cover the upfront cash flow.
What?
A week later, the developer calls and says, Sorry, the board changed their minds. The project is scrapped. As an industry professional, how do you even begin to unravel the legal mess of that handshake? Like, is there an enforceable contract?
Well, the visceral reaction for most people is just no, because there's no paperwork.
Right.
But the true professional answer is yes. Under very specific conditions, a verbal agreement can absolutely be legally binding. The law exists to protect the public and give life to agreements, not to punish parties simply because they didn't formalize it in writing.
Sure.
However, actually proving it is a total nightmare.
Because it turns into a game of he said, she said?
Precisely. To prove that handshake was a contract, you have to demonstrate that the core elements of contract formation were present at that dinner table.
Okay, break those down.
First, offer and acceptance. Did the developer make a definitive offer to build the toll road? And did the contractor definitively accept it? Then there is consideration, which is the mutual exchange of value.
So the contractor promises to build the road, the developer promises to pay for it.
Exactly. But it doesn't stop there.
Well, wait, what if the developer was heavily intoxicated during that dinner? I mean, you mentioned wine.
That goes straight to the element of capacity.
Ah.
For a meeting of the minds to occur, both parties must be legally and mentally capable of entering the agreement. If one party is completely inebriated, they lack capacity, and the contract is voidable.
That makes sense.
You also have the element of legality. I mean, if they were shaking hands to build an illegal smuggling tunnel across a border, the courts won't enforce it, no matter how much money changed hands.
Right, obviously.
And finally, possibility. The project must be physically and legally possible to execute.
Okay, let's assume they were completely sober, the road is perfectly legal, and the offer was clear. The contractor is just sitting there with millions of dollars in leased bulldozers for a canceled project. How do they actually recover those costs without a signed document?
This is where we introduce the equitable doctrine of promissory estoppel.
Promissory estoppel?
Yes, it is a critical concept to understand for the APC. It acts as a safety net in common law. The doctrine essentially says that if Party A makes a clear, unambiguous promise to Party B, and Party B relies on that promise to their own detriment, meaning they spend real money or alter their position,
right,
and Party A knew or should have known they would rely on it, the courts can step in and force the promise just to prevent a gross injustice.
So in our scenario, the promise is the award of the toll road. The detrimental reliance is the contractor taking out that loan and leasing the bulldozers. But there's a catch there, right? The burden of proof.
Oh, a massive burden of proof. The contractor has to prove to a judge that the developer was fully aware of the mobilization.
Because if the contractor just went rogue and leased the equipment in secret, the developer might not be liable.
Exactly. But if the contractor can prove the developer knew, they can seek compensation. Now, they won't get the lost profit of the entire unbuilt toll road, right? But they can recover their abortive costs to put them back in the financial position they were in right before that dinner.
Okay, but what if they had actually started turning dirt? Say they spent 3 days grading the land before the cancellation call came in.
Then you bring in another principle, quantum meruit.
Which means?
It translates to as much as is deserved. The law absolutely hates unjust enrichment. The developer cannot just receive 3 days of free site preparation. Even without an agreed contract price, quantum meruit allows the courts to calculate a fair and reasonable valuation for the services actually rendered and force the developer to pay it.
See, that is the exact level of depth an APC panel wants. You aren't just reciting a list of elements. You are applying promissory estoppel and quantum meruit to protect a client's commercial position in real time.
It's the whole point of the interview.
But let's be real, handshakes are pretty rare for multi-million-dollar jobs. What is far more common and arguably just as dangerous is the letter of intent, the LOI.
Oh, the infamous LOI. It is literally the duct tape of the construction industry.
It really is. A client issues an LOI and the contractor takes it and just immediately starts pouring concrete. But fundamentally, is an LOI a valid contract for the whole project?
Absolutely not. At its core, an LOI is merely a statement of intention. It is a document saying, we intend to enter into a formal contract with you at a later date. It's just a preliminary agreement.
Then why on earth are they everywhere? If they aren't the main contract, why do clients risk using them at all?
Because in construction, time is the ultimate currency.
Always.
Let's say you are building a massive data center. The formal contract negotiations finalizing the risk matrix, the warranties, the liability caps, that might take 3 months to iron out. But the client needs the site cleared today. Or maybe they need to order bespoke microchips that have a 50-week lead time.
Right, they can't wait.
Exactly. The LOI bridges that agonizing gap between the decision to award the project and the execution of the final contract document.
So if you are advising a client who insists on using an LOI just to get the shovels in the ground, how do you engineer that document so it doesn't just blow up in their face? Because, if negotiations fail 2 months later and the contractor has already built the foundation, you are in a massive commercial void.
You have to draft the LOI not as a promise for the future, but as a mini-contract for the present.
A mini contract.
Right. A robust, protective LOI must have 3 strict boundaries. First, it needs a crystal clear scope. You are not authorizing them to build the entire data center. You are authorizing them only to clear the site and order the structural steel.
Okay, so ring fencing the work.
Yes. Second, it must have a strict financial cap and a time limit. For example, you say you're authorized to expend up to $500,000 or work for 30 days, whichever occurs first.
That puts a hard ceiling on the client's exposure.
Precisely. If they hit $500,000, they must stop work entirely unless a new LOI or the main contract is signed. And third, it absolutely must include a dispute resolution and termination mechanism.
Because if it all goes wrong...
Exactly. If the main contract is never agreed upon, the LOI dictates exactly how the contractor gets paid for that early work and how they safely demobilize from the site. Without those caps, a contractor will just keep building under the illusion of the LOI, and when a dispute inevitably arises over, say, a defect or a delay, you have no contractual framework to rely on to assess liability. It's basically commercial suicide.
It's the difference between hoping for the best and engineering for the worst, which perfectly sets up one of the most misunderstood legal doctrines in the industry. And a favorite trap for APC assessors, by the way. We need to talk about frustration.
The ultimate escape hatch. Or at least what people mistakenly believe is an escape hatch.
I see this all the time. Let's say we are halfway through building a high-rise residential tower. Suddenly, a massive shift in government legislation dictates that the specific type of imported cladding we are using is now deemed a severe fire hazard.
Very topical.
Right. It becomes completely illegal to use or even possess on site. The contractor looks at this, throws their hands up, and says, the contract is frustrated, it's illegal to build, we are terminating and walking away. Can they do that?
The short answer is almost certainly no. But to understand why, you have to understand how rigid the common law doctrine of frustration actually is.
Okay, lay it out for us.
Frustration occurs when an unforeseeable event, arising after the contract is formed, makes the performance of the contract literally impossible, illegal, or radically different from what the parties originally intended.
But wait, banning the primary cladding material sounds like it makes the design illegal. That fits.
It does make it illegal. But the test for frustration has 3 incredibly strict hurdles. First, the event must be truly unforeseeable by an experienced professional. Second, the event must not be the fault of either party. I mean, you cannot self-induce frustration through your own negligence.
Sure.
But it is the third hurdle that trips everyone up. There must be absolutely no express provision in the contract that already deals with the event.
Ah, the contractual override.
Exactly. If you are using a sophisticated standard form of contract, whether it's from the FIDIC suite for international works, the JCT suite for UK building projects, or the NEC suite for collaborative infrastructure, those contracts are hundreds of pages long for a reason.
They anticipate disaster.
They do. They contain clauses for force majeure or exceptional events. And crucially, they contain change in law clauses.
So if the contract already says, hey, if the law changes, here's how we handle it, the doctrine of frustration is just completely deactivated.
Because the risk has already been allocated by the parties. Frustration only applies when there's a total contractual vacuum. If a change in law clause exists, the contractor cannot just walk away. They must follow the machinery of the contract. They might have to submit a variation to redesign the facade with legal cladding, claim an extension of time, and negotiate the cost implications. The contract survives.
What happens in the incredibly rare event that a contract actually is frustrated? Say, I don't know, a meteorite hits the site, or the government permanently requisitions the land for a military base, and there genuinely is no clause covering it.
Well, if true frustration occurs, the contract is automatically terminated at that exact moment. But it is vital to note that it is not void ab initio.
Meaning?
Meaning, it is not canceled from the very beginning as if it never existed. The contract was totally valid up until the frustrating event. Therefore, all future obligations are discharged, but the parties must settle up financially for the work completed up to that point.
Mm-hmm.
The common law often leaves the losses to lie where they fall, which can frankly bankrupt a contractor who has sunk millions into preliminary site setup that they haven't billed for yet.
Which is exactly why we rely on standard forms of contract in the first place. We want certainty. We want a rule book that dictates who pays when disaster strikes, rather than just leaving our fate to the whims of a judge applying common law equity.
Exactly.
But to get that certainty, you have to choose the right rule book in the first place.
You have to build the right vehicle before you start driving.
Right. Which brings us out of the realm of pure legal theory and into the strategic core of our masterclass, procurement and tendering. Because getting this wrong is the root cause of, 90% of construction disputes?
At least 90%.
Right.
Procurement is simply the strategy of how you buy the building. It dictates the relationship between the client, the designers, and the builders. It determines who holds the risk for design errors, who controls the schedule, and ultimately who eats the cost when things go wrong.
Let's put you back in the hot seat with a scenario.
Let's do it.
I am a healthcare developer. I am commissioning a highly complex, state-of-the-art oncology hospital. We are talking heavily shielded radiation bunkers, incredibly strict negative pressure airflow systems, and completely bespoke surgical suites. I am coming to you for advice. My primary drivers are absolute cost certainty before I start and total uncompromising control over the design and specification.
Okay.
I cannot afford a single design flaw, even if it means the project takes a year longer to build. Which procurement path do you recommend?
When a client presents those specific drivers, I immediately look to the iron triangle of project management: time, cost, and quality.
The classic triangle.
Right. And you can rarely optimize all three simultaneously. Prioritizing one usually means sacrificing another. This client has explicitly stated that quality, meaning total design control, and cost certainty are their absolute priorities, and they are totally willing to sacrifice time.
Right.
Therefore, the only logical recommendation is the traditional procurement path, specifically using a sequential method.
Walk us through how traditional procurement actually functions in reality. Why does it protect quality so well?
In the traditional route, the processes of design and construction are completely separate and sequential. The client hires their own professional design team first: architects, structural engineers, MEP consultants. This team designs the hospital down to the microscopic level. Every duct, every radiation shield, every door handle. The design is pushed to 100% completion before any contractors are ever invited to bid on the project.
So the contractor isn't designing anything, they are just pricing exactly what is on the page.
Exactly. Because the design is complete, a quantity surveyor can produce a highly detailed bill of quantities. The contractors price this bill, which provides the client with a high cost certainty they demanded. They know the exact price before the first shovel hits the dirt. The contractor takes the financial risk of building that exact design for the agreed lump sum.
But where does the risk sit if the design itself is flawed? What if the architect's negative pressure system doesn't actually work once it's built?
That is the trade-off of traditional procurement. The client retains total control over the design team, which means the client retains the risk for their performance.
So you own the mistakes.
Yes. If the airflow fails because of an engineering miscalculation, the contractor is entirely blameless. The contractor will just say, "I built exactly what you drew." The client then has to pay the contractor a variation to rip it out and fix it, and then the client must separately try to sue their engineer for professional negligence. But for a highly specialized facility like an oncology ward, retaining that design control is almost always worth that risk.
It makes perfect sense. But let's throw a massive commercial wrench into the gears.
Go for it.
I'm the exact same developer. My board of directors just called me in a total panic. We have secured a massive pharmaceutical company as our anchor tenant for the hospital, but they have a hard deadline. They need us to open the facility 8 months earlier than our traditional schedule allows.
Oh, wow. 8 months is huge.
Right. We can no longer afford the luxury of waiting for the design to be 100% finished before we start building. We need to overlap design and construction. We need to be pouring the concrete foundations while the architects are literally still figuring out the roof. What happens to our procurement strategy now?
Well, the entire risk profile just shifted dramatically. If speed is now the dominant driver, the traditional sequential method is dead in the water. To overlap design and construction, we have to fundamentally alter who holds the design responsibility. I would present the client with two primary alternatives: design and build, which is D&B, or a management procurement path.
Let's unpack design and build first. It's incredibly popular right now. How does it achieve that speed?
In design and build, the client transfers the design risk entirely to the contractor. The client produces a document called the employer's requirements, which is basically just a performance brief. They say, I want a hospital, it needs to treat 500 patients a day, and it needs radiation bunkers.
Keep it broad.
Right. The contractor responds with contractor's proposals and a lump sum price. Crucially, the contractor either hires their own architects or takes over the client's original design team through a process called novation.
So there is a single point of responsibility.
Exactly. This is the massive advantage of D&B. If the roof leaks, the client doesn't care if it was a design flaw or a bad installation. They just point at the single main contractor and say, fix it. And because the contractor controls both the designers and the builders, they can easily overlap the processes. They can start digging the basement while their in-house architects finalize the upper floors.
It sounds like the perfect solution. Speed, single point responsibility, lump sum price. Why wouldn't we use D&B for the oncology hospital?
Because you sacrifice the one thing you said you absolutely couldn't lose.
Quality control.
Exactly. Control over quality.
Yeah.
In D&B, the contractor's primary driver is usually their own profit margin. If the employer's requirements are not drafted with absolutely airtight precision, the contractor will logically seek to deliver the cheapest possible solution that still meets the bare minimum standard of being fit for purpose.
So if I didn't explicitly specify hospital-grade antimicrobial door handles in my brief, the contractor is going to install the cheapest standard office handles they can find just to save money.
Yes. And as the client, you have very little power to stop them without issuing a formal variation, which costs time and money. You lose the ability to fine-tune the design as the project progresses. For a standard warehouse or a generic office block, D&B is fantastic. For a highly bespoke oncology facility, giving up that level of design control to a contractor is a terrifying prospect.
So D&B is too risky for our quality requirements, but traditional is too slow. What is the middle ground? You mentioned management paths.
Yes. If a client absolutely must overlap design and construction for speed, but must retain their own independent design team to ensure quality, we utilize management contracting or construction management.
Okay, those two sound identical. What is the structural difference?
The difference lies entirely in the contractual links. In management contracting, the client hires a management contractor early on, purely for a fee. This entity doesn't actually build anything with their own hands. They act as a hyper-sophisticated project manager. They break the hospital down into specialized work packages: the concrete package, the MEP package, the facade package. As the client's design team finishes the design for the concrete, the management contractor tenders that specific package and signs a contract with a concrete subcontractor. Crucially, the management contractor holds the contractual links with all these trade contractors.
And how does that differ from construction management?
In construction management, the construction manager acts merely as a consultant. They organize the packages and run the site, but the client signs direct contracts with every single trade contractor. The client might hold 40 different contracts for one hospital.
That sounds like an administrative nightmare for the client.
It is incredibly resource-intensive. It requires a client with a massive, highly experienced in-house legal and commercial team. But both of these management methods solve the client's core problem. You get the speed of overlapping design and construction, and you retain total control over your design team to ensure those radiation bunkers are perfect.
But what is the trade-off? Because there is always a trade-off.
You completely lose cost certainty.
Right.
In a management route, you do not know the final total price of the hospital until the very last work package is tendered and signed, which might be a whole year into construction. If inflation spikes midway through the project, the client absorbs that risk directly.
It is a brilliant analysis. You've demonstrated to the APC panel that you don't just know definitions. You understand how manipulating the contractual structure dictates commercial outcomes.
Thank you.
Let's assume the client chose the management contracting route. We need to hire that management contractor early before the design is finished, which means we can't do a standard open tender where everyone bids a lump sum because there's nothing to actually price yet.
Right. We have to use a two-stage tendering process.
Explain the mechanics of a two-stage tender. Assessors absolutely love this topic because it tests your understanding of negotiation leverage.
Two-stage tendering is designed to bring a contractor's logistical and buildability expertise into the design process early. In stage one, we aren't asking them to price the whole building. We invite a select group of contractors to bid competitively on their preliminaries, which are their site running costs, like cranes, management staff, and site huts, along with their overheads and profit margin percentage. We might also ask them to price an indicative schedule of rates for major items.
So we select a winner based on who has the cheapest running costs and profit margins. What happens in stage 2?
The winner of Stage 1 joins the client's team under a pre-construction services agreement, a PCSA. They sit with the architects, they advise on how to build the hospital faster, they help identify supply chain bottlenecks.
Very collaborative.
Right. Then, as the design actually gets finished, we move into Stage 2. The contractor uses those pre-agreed profit margins and rates from Stage 1 to build up an actual lump sum price for the works. It is a negotiation. If the client and contractor can agree on the final number, they sign the main building contract.
And if they can't agree?
If they can't agree, the client pays the contractor for their pre-construction advice, terminates the PCSA, and can legally walk away to find another builder.
Okay, let's introduce the APC trap here. You are evaluating the Stage 1 bids. You have 5 contractors. You notice a massive anomaly. The lowest overall bidder, the one the client is eagerly pointing at and wants to hire, has heavily, aggressively front-loaded their preliminaries.
Ooh, red flag.
Right. Their costs for month 1 mobilization, site setup, initial management fees are astronomically high, while their costs for the final 10 months of the project are suspiciously low. Why is a contractor doing this, and what is your advice to the client?
The contractor is manipulating the bid to optimize their cash flow. They're trying to extract as much cash out of the project as early as possible. If they win, they will be cash positive from day one, essentially using the client as an interest-free bank to finance their operations.
Yeah.
Or perhaps even using that early cash to plug financial holes they have on other failing projects.
To make this visceral, I always compare front-loading to hiring a personal trainer.
Oh, I like this.
Let's say you want to get fit, and a trainer offers you 50 sessions for $5,000. Normally, you'd pay $100 per session. But this trainer says, I'll give you a discount, but you have to pay me $4,000 on day 1 and then $20 a session for the rest of the year. It sounds like a deal. But what happens by month 6?
By month 6, the trainer has pocketed 80% of your money, but you've only received 20% of the workouts. You have completely lost your commercial leverage. If the trainer stops showing up, you can't withhold payment to force them back, because you've already paid them. You are deeply out of pocket.
Exactly. So translate that back to our hospital project. What is the catastrophic risk of accepting this front-loaded bid?
The ultimate nightmare in construction: contractor insolvency. If you accept a heavily front-loaded bid, you are paying out cash far faster than physical values being built on the site. If that contractor goes bankrupt halfway through the project, the client has vastly overpaid for the concrete currently sitting in the ground.
And when the client has to go out to the open market to hire a replacement contractor to finish the half-built hospital, they won't have enough money left in the original budget to afford it.
Precisely. They will be financially underwater. Therefore, my advice to the client is that this bid represents an unacceptable commercial exposure.
Do you just toss the bid in the trash?
Well, I wouldn't instantly disqualify them if they are genuinely a good contractor. During the post-tender interview, I would put the anomaly squarely on the table. I would demand they justify the early costs. If they can't provide a legitimate logistical reason, I would require them to flatten their preliminary cash flow curve, distribute the costs evenly across the program duration before we even consider accepting the bid. If they refuse, it indicates bad faith or severe financial distress, and we move to the second lowest bidder.
That is exactly how you demonstrate safe hands to a panel. You protected the client's risk profile during procurement, and you protected their cash flow during tendering.
It's all about foresight.
So the contract is signed. The honeymoon period is over. The shovels hit the dirt. We are moving into the crucible of post-contract administration. This is where theory collides with the chaotic reality of a live construction site.
This is where you have to understand the sheer volume of data, money, and time that is constantly shifting every single day.
Let's put you right into the fire. We are administering a project using the FIDIC Red Book, a standard form heavily used internationally for employer-designed works. We are in month 6 of a 3-year build. The contractor submits their monthly interim payment application. You are going through the massive spreadsheet, and you hit a line item that makes you stop cold.
Okay.
The contractor is claiming a multi-million-dollar payment for 5 bespoke, highly specialized hospital chiller units. But here is the problem. Those chillers are not on site. They are currently sitting in a manufacturing facility in Germany. Our project site is in Dubai. And the construction schedule dictates that those chillers won't actually be installed in the building for another 15 months. Do you, as the certifying engineer or quantity surveyor, approve this payment?
This is the classic materials offsite dilemma.
Yeah.
My default instinctual position is extreme caution. Certifying payment for materials that are thousands of miles away, sitting in a foreign jurisdiction, and not yet incorporated into the permanent works is incredibly risky. I mean, if I blindly certify that payment and the German manufacturer goes bankrupt tomorrow, the client just lost millions.
Though you reject it.
However, I wouldn't reject it outright. Standard contracts do allow for off-site payments, but only if a rigorous, non-negotiable checklist is fulfilled to protect the employer's money.
Walk us through that checklist. What is step one?
Step one is checking the contract documents. Is payment for materials off-site even permissible for this specific item? I would check the appendix to tender or the specific conditions. Standard forms usually require that eligible items be explicitly listed. You aren't going to pay off-site for generic bricks or bags of cement.
Right, stuff they can buy anywhere.
Exactly. But for bespoke, long-lead items like specialized chillers, it is highly probable they are a listed, eligible item.
Let's assume they are on the list. The contractor is legally allowed to ask for the money. How do you actually secure the asset?
We must secure legal ownership. If the employer is paying for those chillers, the employer must unequivocally own them, even while they sit in Germany. I would mandate the execution of a vesting certificate. This is a legally binding document that explicitly transfers the legal title and ownership of those specific chillers from the manufacturer or the contractor directly to the employer.
Why is that piece of paper so critical, though? I mean, it's just a piece of paper.
Because of insolvency law. If that German factory goes into liquidation, the liquidators will come in and seize all the assets in the warehouse to pay off the factory's debts. If we have a valid vesting certificate, those chillers are legally fenced off. They are the property of our client, and the liquidator legally cannot touch them.
But wait, a liquidator looking at a massive warehouse full of identical metal boxes needs to know which boxes belong to you.
Exactly. So the vesting certificate must be paired with physical segregation. The chillers must be clearly set aside in the factory, wrapped and heavily labeled with the project name and the employer's name. They must be visibly identifiable as our property. Furthermore, before I certify a dime, I need proof they actually work.
Right, you don't want to buy broken chillers.
I would require factory acceptance testing reports, or I would send an independent third-party inspector to the facility in Germany just to verify they meet the exact specifications.
So we have legal title, we have physical segregation, and we know they work. Are we safe to pay? What about physical risk? What if the factory burns down or the cargo ship transporting them across the Mediterranean sinks?
That is the final crucial step: insurance. The standard contractor's all-risk insurance policy typically only covers materials once they physically cross the boundary of the construction site. It does not cover materials sitting in a foreign factory or during international transit.
That's a huge gap.
It is. Therefore, I must compel the contractor to provide separate, specific insurance policies like marine cargo insurance, covering the full replacement value of the chillers while they're off-site and in transit. And the employer must be named as a co-insured or joint beneficiary on that policy.
That is a phenomenal breakdown of the protective mechanisms. But APC panels want to see your commercial brain working. Why is this situation happening at all? Why on earth is a contractor buying chillers 15 months before they need them?
It is entirely about supply chain risk management. The contractor might be securing those chillers today to lock in the current steel and component prices, protecting themselves and potentially the client from massive hyperinflation over the next year.
Ah, hedging against inflation.
Yes. Alternatively, they might be securing their spot in the manufacturer's production queue. If they wait another 6 months to order, the factory might be booked up, and the chillers will arrive late, delaying the opening of the entire hospital.
But from the employer's perspective, paying out millions of dollars 15 months early is a massive hit to their cash flow. It's an opportunity cost. That money could be sitting in the employer's bank earning interest.
It is a severe commercial tension. It's a balancing act. Paying early hurts the employer's cash flow, yes, but refusing to support the contractor's proactive procurement strategy might lead to catastrophic supply chain failures later on. If the contractor is acting prudently to mitigate risk, and if all the safeguards, the vesting certificate, the labeling, the insurance are bulletproof, it is often in the employer's strategic best interest to certify the payment.
It is about seeing the bigger picture beyond just the monthly spreadsheet. Speaking of cash flow, let's talk about one of the most contentious mechanisms in construction: retention. I've always viewed retention as basically a legalized hostage situation.
It essentially is a hostage situation, but one that is meticulously engineered to keep the project breathing and the contractor motivated.
Let's explain the math to the listener. Standard contracts usually dictate that we hold back a percentage, say 5% of every single interim payment we make to the contractor. If they do $1 million of work this month, we only pay them $950,000. We hold that $50,000 in a retention fund.
Right.
Over a 3-year, $100 million project, that retention pot grows to a massive $5 million. But here is the behavioral question for you. Standard forms dictate that we release half of that massive fund, $2.5 million, back to the contractor the exact moment practical completion is achieved, meaning the day they hand over the keys. The defects liability period hasn't even started yet. Why do we give them half the hostage money back when we might need it to fix defects?
Because of the psychology of incentivization. That 50% release is a massive dangling carrot. For many contractors, especially in tight economic markets, that first half of the retention represents their entire profit margin for the job. Everything they earned before that merely covered their costs.
So they are desperate for it.
Extremely desperate. And the employer uses that desperation. The end of a construction project is notoriously difficult. The final 5% of the work, the testing, the commissioning, the final paint touch-ups, producing the operation manuals, is tedious, expensive, and frustrating. Without a massive financial incentive, contractors will drag their feet. By promising to release millions of dollars the exact day they achieve practical completion, the contract aggressively incentivizes the contractor to sprint across the finish line and hand the building over on time.
It leverages their need for cash to guarantee the client gets their building, and the remaining 50%, the other $2.5 million.
That is held throughout the defects notification period, which is typically 12 or 24 months after handover. Even the best contractors leave minor defects behind, or latent defects become apparent once the building is actually being used. The remaining retention incentivizes the contractor to answer the phone and return to the site to fix those defects quickly.
And if they ignore the phone calls?
If they refuse, the employer uses the retention money to hire someone else to fix it. Once all defects are rectified, the engineer issues the final performance certificate and the final retention is released.
But what if holding that 5% during the build actually suffocates the contractor's cash flow so severely that they go bankrupt before they even finish? We talked about insolvency earlier.
That is a very real danger in today's market. To prevent that, sophisticated clients will allow the contractor to provide a retention bond. The client pays the contractor 100% of their money every month, keeping the contractor's cash flow extremely healthy. In exchange, the contractor provides a guarantee from a major bank. If the contractor defaults or fails to fix defects, the client can call in the bond and the bank pays the client the retention amount. It transfers the risk to the banking sector.
It's a brilliant commercial compromise. All right, take a breath, because we are about to enter the darkest, most complex area of post-contract administration. You cannot achieve chartership without surviving this topic. We are talking about concurrent delays.
The Gordian knot of construction law.
Here is your scenario. We are building the hospital. We are on the critical path, pouring the main structural concrete. A freak, torrential, unforeseeable 100-year storm hits the site. It completely floods the foundations. All work is violently halted for exactly 1 week. Under the contract, extreme adverse weather is a neutral event or a contractor risk event regarding cost. The contractor is entitled to an extension of time so they don't get penalized for being late, but they do not get any additional money to cover the running costs during that week.
That is standard risk allocation. The employer isn't responsible for the weather.
Exactly. But here is the twist. During that exact same week that the site was flooded, the client's architect completely failed to issue the critical structural drawings required for the next phase of work. Without those drawings, the contractor couldn't have worked anyway, even if the sun was shining.
Okay, I see where this is going.
Right. A failure by the architect to issue drawings is an employer delay event. Normally, this entitles the contractor to both an extension of time and financial compensation for their extended site costs. So we have a perfect concurrent delay. Both parties caused a delay at the exact same time. How do you resolve this? Does the contractor get the time? Do they get the money?
This specific scenario has generated decades of complex litigation. Because standard contracts like older FIDIC or JCT versions didn't always have a mathematically perfect formula for it, professionals have to rely on established case law and industry gold standards, specifically the Society of Construction Law's delay and disruption protocol.
What is the SEL's definitive stance on this? Let's start with the time. Do they get the extension of time?
Yes. The standard resolution for true concurrent delay is that the contractor is fully entitled to the extension of time.
Play devil's advocate here. Why? If the site was flooded and they couldn't work anyway, why should the employer grant them an extension just because the architect was late with the drawing?
Because of a fundamental legal concept called the prevention principle. The law states that a party cannot enforce a contractual obligation like a strict completion date if they themselves prevented the other party from fulfilling it. Even though it was raining, the architect's failure prevented the work. Therefore, the employer cannot enforce the completion date, and more importantly, they cannot levy massive liquidated damages against the contractor for missing that date. The contractor gets the time to shield them from penalties.
Okay, that protects the contractor's downside. But what about the money? Do we pay the contractor for their site overheads, their crane rentals, and their project manager's salaries for that week they spent sitting in the flooded mud?
No. They are absolutely not entitled to recover preliminary costs, loss, or expense for that concurrent period.
Again, defend that. The employer's architect delayed them. When the employer delays you, they pay you.
The core legal reasoning here is causation and the prevention of unjust enrichment. A culpable party cannot hide their own risk event behind the fault of the other party to make a profit or recover costs they would have suffered anyway. Let's look at the reality. If the architect had performed perfectly and delivered the drawings exactly on time, what would have happened?
The contractor still would have been sitting in the mud for a week because of the flood.
Exactly. They still would have paid the crane rentals and the salaries while doing absolutely no work. The rain was the contractor's risk event regarding cost. They cannot point to the architect's simultaneous failure to magically recover the financial losses caused by the weather. The SEL protocol is very clear. Where an employer delay and a contractor delay are concurrent, the contractor gets time, but no money. Time, but no money.
It is a brutal reality check. Contractors often view an employer mistake as a lottery ticket to recover all their losses. When you tell them time, but no money, the relationship often breaks down entirely. The amicable negotiations fail, the letters get aggressive, and the administration phase ends. We are forced into the final, most adversarial phase of the project lifespan, claims and disputes.
This is where the paperwork stops being a management tool and becomes a weapon.
Let's look at how that weapon is wielded. I am the contractor on the hospital project. It has been a total disaster. The weather was awful. The design changed 50 times. The supply chain broke. I walk into your office and drop a 50-pound cardboard box on your desk.
I can picture it now.
It is filled with thousands of disorganized receipts, timesheets, and concrete invoices. On top is a single sheet of paper that says, the employer caused 50 different delays and massive disruption. Our original budget was $100 million. We spent $110 million. Therefore, the employer owes us a total financial loss of $10 million. Pay up. As the assessor, how do you handle this?
I would look at that box, recognize it immediately as a global claim, and prepare for a very intense fight. Assessors, commercial managers, and the courts absolutely despise global claims.
Why the hatred? I mean, if they have the receipts proving they spent $10 million more than they planned, shouldn't they be made whole?
Because a global claim fundamentally violates the most basic requirement of contract law, establishing a direct cause and effect nexus. You cannot just point to a pile of money you lost and say, you did some bad things, so you must owe me this money.
You have to connect the dots.
Precisely. You must meticulously prove that breach A directly caused loss A. The contractor might have lost that $10 million for a dozen reasons that have nothing to do with the employer. Maybe their own project manager was entirely incompetent. Maybe they suffered massive internal material theft. Or, most commonly, maybe they deliberately underpriced the tender by $10 million just to win the job, and now they're trying to claw back their commercial mistake by blaming the employer's design changes. The employer is not an insurance policy for the contractor's bad estimating.
So do you just throw the box in the trash and reject the $10 million claim outright?
I would formally reject it in its global format. The courts have consistently ruled that unless it is genuinely physically impossible to disentangle the overlapping delays, which is almost never true if they kept proper daily site records, a global claim is invalid. I would force the contractor to take the box away and completely rebuild their claim using a highly disciplined method, like a measured mile analysis.
Break down the measured mile for the listener. How does it prove cause and effect?
It isolates the disruption. I would tell the contractor, go into your records and show me a period on this project where you were working normally, without any employer interference. Let's calculate your baseline productivity. Say, during month 2, you were laying 1,000 bricks a day with a team of 10 men. Now show me the specific period where the architect issued late, confusing drawings.
Ah, I see.
Right. If, during that specific disrupted period, your 10 men were only laying 400 bricks a day because they were waiting for clarification, we can precisely isolate that 60% loss of productivity. We value that specific loss of 600 bricks a day and tie it directly to the architect's specific breach. It forces discipline, logic, and undeniable cause and effect.
It protects the employer from subsidizing the contractor's own inefficiencies. But let's flip the script. The disputes aren't always about the contractor wanting more money. What happens when the contractor is disastrously late? The hospital was supposed to open on January 1st. It is now May.
Ouch.
The contract clearly states that for every single day the contractor is late, they owe the employer $100,000 in damages. We withhold millions from their payment.
Yeah.
The contractor's lawyers immediately send a letter arguing that this $100,000 a day is an unenforceable penalty. How do we defend this in common law? What is the difference between a valid damage and an illegal penalty?
This distinction is critical, and the terminology is everything. We are talking about liquidated damages, or LDs, versus penalties.
Define a valid liquidated damage.
A liquidated damage is a genuine, reasonable, pre-agreed estimate of the actual financial loss the employer will suffer if the project is handed over late. The absolute key factor is that this calculation must be made at the time the contract is formed, not retroactively after the delay happens.
Walk me through the actual math of that calculation for our hospital.
If the hospital is late, the developer loses the monthly lease revenue from the anchor tenant. They have to pay extended fees to their project managers and site security for staying on site longer. They might have to pay exorbitant climate-controlled storage fees for MRI machines that can't be installed yet. They have extended financing charges on their bank loans. If you tally up all those genuine, highly foreseeable daily losses, and the math comes out to roughly $100,000 a day, then that is a perfectly valid liquidated damage clause.
And courts will back that up.
Vigorously, because it provides commercial certainty. Neither party has to go through a massive trial to prove the exact dollar amount of the loss. They agree to the estimate on day one.
So what turns that valid clause into an unenforceable penalty?
A penalty is an arbitrary, excessively high figure that is designed purely in terrorum, which is a legal term, meaning designed to terrorize, punish, and threaten the contractor into submission. If the developer's actual estimated daily loss was only $15,000 a day, but the developer put $300,000 a day into the contract just to terrify the contractor into working night shifts, that is a penalty. Under common law, punitive clauses in civil contracts are legally void. You cannot use a contract to punish, you can only use it to compensate for genuine loss.
But this raises a massive practical problem. How do you prove it was a genuine pre-estimate if you end up in an arbitration hearing 3 years after the contract was signed? The lawyers will demand proof.
That is the exact trap assessors want to see if you can avoid. The practical answer is you must meticulously maintain the calculation sheet. The quantity surveyor or commercial manager must save the original Excel file where they calculated the tenant revenue, the consultant fees, and the interest charges. You attach it as an appendix to the tender documents, or at the very least, lock it in the project file. When the contractor's lawyer claims it's a penalty 3 years later, you slide that Excel sheet across the table and say, no, it was a mathematically genuine estimate of our exposure at the time of signing. Here is the proof.
Evidence is everything. Now let's look at a dispute that happens long after the project team has disbanded. The hospital is finished. It has been open and operating for 5 years. Suddenly, massive cracks appear in the basement foundation. Groundwater is seeping into the radiation bunkers. This is a latent defect, a hidden flaw in workmanship that only manifests years later.
Go total nightmare.
The problem is, the entity currently operating the hospital, let's call them the National Healthcare Trust, was not the original developer who signed the building contract. Because of the foundational doctrine of privity of contract, the healthcare trust has no direct legal relationship with the original builder. How on earth do they sue the builder to fix the massive structural failure?
You've hit on a major flaw in construction law. The doctrine of privity of contract essentially dictates that only the actual parties who signed a contract can sue or be sued upon it.
Huh.
Third parties have no rights. The healthcare trust is a third party. To bridge this gap, the industry relies on a mechanism called collateral warranties.
Explain the mechanics of a collateral warranty. How does it bypass the privity rule?
A collateral warranty is a separate secondary standalone contract. During the main construction phase, The developer's contract will include a strict clause mandating that the main contractor and often the key structural designers and major subcontractors must execute these collateral warranties in favor of any future tenants, purchasers, or financial backers of the building.
So it creates a direct legal bridge where none organically existed.
Exactly. The warranty essentially says, I, the original builder, warrant directly to you, the future hospital operator, that I constructed this building using reasonable skill and care in accordance with the original contract. If a latent defect appears 5 years later, the healthcare trust doesn't need to track down the original developer. They use that collateral warranty to sue the builder directly for breach of contract.
But what if the builder went bankrupt 2 years ago? The industry is volatile. A warranty from a liquidated, dead company is just a worthless piece of paper.
That is the ultimate risk, and it happens constantly. To mitigate that catastrophic risk, a sophisticated professional would advise the client to procure decennial liability insurance, sometimes called inherent defects insurance. This is a first-party, non-cancelable insurance policy that covers the structural integrity of the building for 10 years after completion. If the foundation cracks, the insurance company pays to fix it immediately, regardless of whether the original contractor is bankrupt, dissolved, or even at fault. It avoids years of litigation entirely, though the upfront premiums for the policy are massive.
It is the ultimate safety net. Okay, let's pull back. The project is bleeding, we have concurrent delays, rejected global claims, and arguments over liquidated damages. The relationship between the client and the contractor has completely deteriorated. We need to resolve this. But absolutely nobody wants to go to formal court litigation. It is incredibly public, it takes years, and the legal fees will destroy whatever profit is left. Outline the alternative dispute resolution, or ADR, processes that are embedded in standard contracts to keep us out of the courthouse.
Standard forms like FDI or NEC are designed to force the parties to de-escalate. They build in a tiered sequential escalation process. You cannot jump straight from a disagreement to a multi-million-dollar lawsuit. You have to climb the ADR ladder.
What is the first rung of that ladder?
The first rung is always negotiation and amicable settlement. When the engineer or project manager makes a formal determination on a claim and one party is dissatisfied, they issue a notice of dissatisfaction. But the contract then mandates a strict cooling-off period, usually 28 or 56 days. During this window, neither side can escalate the dispute. The senior executives of both companies, people who are removed from the emotional daily warfare of the site, must sit down in a room and attempt to negotiate a purely commercial, pragmatic settlement.
But what if egos get in the way? What if the executives refuse to yield and the amicable settlement fails? What is the next rung?
We move up to mediation. We bring in a neutral third party, a mediator. It is vital to understand that a mediator is a facilitator, not a judge. They have absolutely no power to force a decision or dictate a settlement.
Then why use them? How do they actually resolve anything if they have no power?
It is entirely about psychology and face-saving. The mediator uses shuttle diplomacy. They put the two parties in separate rooms, they go to the contractor, and privately point out the glaring weaknesses in the contractor's global claim. Then they go to the client's room and point out the severe risks in their liquidated damages calculation. They break down the hubris on both sides, making them realize that going to trial is a massive risk. They guide the parties toward a voluntary compromise. It is fast, it is strictly confidential, and it is highly effective because the parties retain total control of their own destiny.
But what if the dispute isn't about money or ego, but about a highly technical, obscure engineering standard? Say, a massive argument over whether the chemical composition of the concrete mix met a specific ISO standard. Mediation won't solve that.
In that scenario, we step sideways to expert determination. The parties jointly appoint an independent, highly specialized technical expert, a veteran structural engineer, or a metallurgist, not a lawyer. This expert investigates the specific technical issue, runs their own tests, and issues a decision based purely on their expert knowledge. Depending on what the parties agree to, this decision can be binding or non-binding. It cuts through the legal posturing and solves the technical root cause.
And if all of that fails, we're talking tens of millions of dollars in dispute, a complete collapse of trust, and no compromise in sight. What is the final destination?
The final binding step in almost all major international construction contracts is arbitration.
Let's deep dive into this. Why do standard forms mandate arbitration instead of just letting the parties sue each other in a national court of law?
There are three massive structural advantages to arbitration. First, privacy. Court cases are public record. Your company's dirty laundry, your profit margins, and your internal emails will be exposed to the media and your competitors. Arbitration is strictly confidential, the hearings are closed, and the awards are private.
Second advantage.
Expertise. In a public court, your highly complex dispute over a critical path delay analysis might be assigned to a judge whose entire career has been spent in family law or criminal proceedings. In arbitration, the parties get to choose their own tribunal. You could appoint 3 arbitrators who are veteran construction lawyers or former civil engineers. They understand the industry language inherently.
And the third advantage, I know this is the most critical one for international mega projects.
Cross-border enforceability. If a UK contractor wins a judgment against a Middle Eastern developer in a London public court, trying to enforce that judgment and seize assets in Dubai is a legal nightmare. But arbitration is governed by the 1958 New York Convention, which has been signed by over 170 countries. Under this convention, international courts are legally obligated to recognize and enforce arbitral awards. If you win an arbitration in Paris, you can easily take that award and enforce it against the losing party's bank accounts in Singapore, New York, or Tokyo. It is binding, final, and globally recognized with lethal efficiency.
That is the ultimate hammer. Okay, before we close out this masterclass, I want to touch on a topic that assessors value above all technical knowledge. You can know every clause of FIDIC, but if you fail this section, you fail the APC instantly. Let's talk about professional practice and ethics.
The RICS Rules of Conduct, or the equivalent for any major institution, is the absolute bedrock of being a chartered professional.
I am going to give you a highly uncomfortable real-world scenario. You are the chartered quantity surveyor acting for the client. You are evaluating final accounts. A major subcontractor who is desperate to get their final payment approved invites you to a lavish industry weekend at a luxury golf resort, all expenses paid. At the same time, you realize that your own brother-in-law is a silent partner in this exact subcontractor's firm. How do you handle this?
That is a walking minefield of ethical violations. As a chartered professional, you must act with integrity, avoid conflicts of interest, and maintain absolute independence. First, the luxury golf trip. You must firmly decline it. The RICS rules are incredibly strict regarding bribery and inducements. Accepting lavish gifts from a party whose financial accounts you are assessing compromises your objectivity, or at the very least, creates the overwhelming appearance of corruption.
And the brother-in-law?
That is a massive, undeclared conflict of interest. You have a personal, indirect tie to the financial success of a company you are supposed to be impartially evaluating. The action here is immediate disclosure. You must immediately inform your employer, the client, and the main contractor in writing about the relationship.
Do you just declare it and keep working?
No. In a conflict this direct, you must recuse yourself from valuing that specific subcontractor's account entirely. You hand that portion of the work over to a colleague. You have to protect the integrity of the process and the reputation of the profession above your own convenience. An APC panel isn't just looking for honesty. They're looking for proactive, documented ethical management.
Brilliant. Navigating the commercial realities while maintaining an unassailable ethical compass.
It is the only way to survive a 40-year career in this industry.
Well, we have reached the end of the gauntlet. If you are listening to this in preparation for your interview, take a deep breath. We have covered an incredible amount of ground today.
We started at the molecular level with contract formation, proving that handshakes and LOIs carry massive, hidden commercial risks.
We navigated the strategic chess game of procurement, understanding exactly why and how we balance time, cost, and quality by shifting risk between traditional and design and build models.
We unpacked the rigorous, unforgiving math of post-contract administration, securing off-site materials with vesting certificates, leveraging retention to drive completion, and untangling the Gordian knot of concurrent delays.
And finally, we survived the battlefield of claims and disputes, stripping away global claims, identifying illegal penalties, and understanding the sheer global power of international arbitration.
Every single decision you make on a project pulls on one of these threads. The invisible legal web is entirely interconnected. You change the procurement route, you change the risk of frustration. You mismanage an LOI, you end up in arbitration. Understanding those connections is what makes you a true professional.
I couldn't agree more. And I want to leave you, the listener, with a final provocative thought to mull over as you head into your interview or your next big project meeting. We have spent the last hour dissecting standard forms of contract like AVD, JCT, and NEC, and analyzing how they allocate risk and manage disputes. But the entire industry is currently undergoing a massive digital and cultural revolution. We are moving rapidly toward highly integrated supply chains, digital twins, and advanced building information modeling (BIM), where the architect, the structural engineer, and the contractor are all designing and clash detecting simultaneously in the exact same shared 3D digital model.
The silos are breaking down technologically.
Exactly. So here's the question. As the technology forces us to work in a completely integrated collaborative environment, will the traditional, heavily adversarial us versus them contract structures even survive the next decade? Or are we on the precipice of a total paradigm shift toward multi-party, shared risk partnering agreements like the NEC4 Alliance contract? Imagine a world where disputes are literally engineered out of existence because the financial success of the client, the designer, and the contractor are all legally bound to a single shared profit pool. If the project succeeds, everyone wins. If it fails, everyone loses together.
It's a fascinating frontier, moving an entire global industry from a culture of aggressive risk allocation to a